Sure, thank you. As Mr. Fitton said, I assume I'm here because the universe of people who know much about the Emoluments Clause or the Ineligibility Clause is kind of small. And little did I know that 13 years ago when I wrote my law review article on the subject that I'd be getting a lot of calls over the last month or so dealing with the Emoluments Clause and how it plays into Senator Clinton's likely nomination as Secretary of State, and now I guess Senator Salazar's likely nomination as Secretary of the Interior. The Emoluments Clause essentially provides that when a federal office is created or the salary of a federal office is increased, the members of Congress at the time are ineligible to be appointed to that office during their current term. So, for instance, with Senator Clinton, her current term began in January of 2007 and would end in January of 2013. And I don't think anybody would question that she's eligible to be Secretary of State once the current term for which she was elected expires in January of 2013. The real question is whether, in the meantime, she's eligible as for appointment as Secretary of State. And I believe the answer to that is no. Some would say that the so-called Saxby fix, which takes the salary of the Secretary of State and reduces it back to the level it enjoyed prior to Senator Clinton's current term, eliminates the problem. Because the theory is that, well, the salary has not been increased because it's exactly where it was when Senator Clinton's term in the Senate began. And I don't think that works for a few reasons, which I'll go through. Probably the main argument making the rounds about why the Saxby fix will restore Senator Clinton's eligibility for appointment is, well, the emoluments of the office have not been increased during her current term because they're equal to what they were when her term began. There's a couple of problems with that theory, I think. One, that's not what the Emoluments Clause says. It doesn't say that a senator is ineligible if the emoluments are higher or if the emoluments simply increase, and that might be a closer call. The clause says a senator is ineligible if the emoluments have been increased, which they clearly have. They were clearly increased in January of 2008. While there are no judicial opinions construing the Emoluments Clause, we're not exactly working on an empty slate here. There have been some Supreme Court decisions dealing with the treatment of federal salaries in connection with federal judges. Article 3 of the Constitution says that federal judges may not have their salary diminished while they're in office. If you buy into the Saxby fix theory, then what you need to do is look at the salary at the beginning of Senator Clinton's term and look at it today or when she's appointed, and if they're the same or at least not any higher, then she's eligible. Well, that was an argument that the United States made with some federal judges back in the 1930s. What happened was there was a federal judge who was appointed and his salary was $8,500. Congress increased the salary to $12,500 and then later reduced it back to about $10,000 a year. And the judge filed suit and said, hey, you've diminished my salary. It went from $12,500 to $10,000. And the United States made exactly the argument that we hear proponents of the Saxby fix making, and that is his salary didn't diminish. His salary went up. He got appointed at $8,500. He's making $10,000 a year now. And the Supreme Court unanimously said that was wrong, that it's not just look at the beginning, look at the end. Any act that lowered the salary was a diminishment. Well, the Saxby fix argument is the flip side of that. The argument that its proponents make is that the salary of the Secretary of State hasn't been increased because you look at the beginning and you look at the end, it's exactly the same. But if you accept that argument, then you'd have to argue that the Constitution uses one method of figuring out if a federal salary's been decreased and a completely different and inconsistent method in trying to figure out if a salary's been increased. It doesn't seem to me that we should construe the Constitution that way. So I think that the way that the Supreme Court has dealt with federal judges pretty much disposes of that argument that there's been no increase if the language of the Constitution didn't do it all by itself. another argument that you hear is there's been no increase in salary because the increase that occurred in January of this year was just a cost of living adjustment. So it really just keeps her salary the same. Inflation means that in real terms, her salary, the salary of the Secretary of State had been going down. So this COLA just makes sure that it stays the same. Again, the Supreme Court considered that argument in dealing with federal judges and rejected it. I mean, if you accept the argument that a COLA adjustment just keeps the salary the same, then I think you have to acknowledge that the absence of a COLA adjustment reduces the salary. And that was the argument that a series of federal judges made in 1980. They said we didn't get a COLA, so in real terms our salary is diminishing. And the Supreme Court, again, unanimously rejected that and said that when you look at the salary, what you look at are the nominal dollars. Your salary was X, it stayed X. You're not constitutionally required to get a cost of living adjustment because your salary is not diminished. Well, if their salary is not diminished, I think then the fact that the increase this year was a cost of living adjustment is necessarily an increase in the salary. It's not just keeping it the same. It's increasing the salary. Another argument that we hear is that the Emoluments Clause doesn't apply because the statute that created this whole regime where by executive order salaries are increased was passed prior to Senator Clinton being in office. I think that's wrong on a couple of levels. One, the Emoluments Clause, I think everyone acknowledges, is a no-fault provision. There's no requirement that a member of Congress have voted for the pay increase or the creation of an office. In fact, you can have voted against it. And more to the point, there's an Attorney General opinion on the books that says that the member of Congress need not even be in Congress when the office is created or the salary is increased, as long as they were elected for the term when it occurred. What happened is a senator got elected, resigned a couple years later, then a year later Congress created the Maritime Commission. President wanted to appoint this former senator, not even in Congress when the office was created. The Attorney General said you can't do it. And you need not even be in Congress. All that really matters is that you're elected for a term, and if there's office created or a salary increase, you're just not eligible till your term ends. We've heard some arguments in the blogosphere that, well, there's a long history behind the Emoluments Clause, and Congress and the President have treated the Saxby fix, where you reduce the salary back to where it was, as satisfying the clause, and that ought to be good enough, that there's precedent now. And so the historical precedent is that this is okay, so that ought to be credited and it ought to remain okay. The real problem with that argument, I think, is that the Emoluments Clause is a restriction on the power of Congress and the President. And in fact, it's a restriction that's focused on preventing collusion between Congress and the President. And it seems to me that Congress and the President can't be the judges of the scope of a clause that's designed to restrict their powers. For more than 200 years, it's been the law in this country that the courts ultimately decide what the Constitution says. So I don't think that there's any basis for saying, yes, this restricts Congress, but Congress decided that it doesn't really apply here. I think that they are not the ultimate arbiter of this issue.